Good morning, everyone. You are all very welcome to the Mason Hayes and Curran webinar. This morning, my name is Liam Riordan. I'm a partner in the education unit. I'm joined by my colleagues, Paul Rochford, who's also a partner in the education unit, and by David Ruddy, barrister at law. David, I'm sure, is well known to many of you. We are delighted that we have over 1,200 participants engaged in the webinar. While we would normally try to make a webinar such as this as interactive as possible, that hasn't been possible given the numbers involved. So we have had to disable the Q&A facility, and I would ask you not to use the chat function. I'm very pleased to say that we received a lot of questions in advance of today, and we will be using those questions during the course of the presentation as a sort of ongoing Q&A in order to throw light on issues as they arise. So without further ado, I'm going to refer you over to David, who will commence the webinar. So David, over to you.
Thanks very much, Liam, and good morning all. And on behalf of Ian O'Hurley, who's head of our education team, again, we'd like to thank some, as alluded to by Liam. And we have a very broad spectrum of school leadership this morning. We have chairpersons of boards, patrons, and of course, principals and deputy principals. And in particular, I'd like to thank the Irish Primary Principals Network, IPPN, for helping us to communicate notice of the webinar. And can I give you a reassurance that at the end of this session, we will email you out the webinar afterwards, because there's, as you can imagine, a lot of information in it. In particular, the main focus really will be the Q question and answer sessions, questions that you have submitted. However, such was the volume, we only could take a certain cohort. And Paul and Liam are very experienced lawyers, and they will offer their guidance in relation to how they see it unfold. So, we're going to start, just reference a number of introductory slides. And that starts with the date in which we must submit our draft policies. Thank you, Paul. The 30th of April is the deadline, and we all work to deadlines. And in that short period of time that's left, we must consult with our parents and staff. The patron has until mid-September to come back with any proposed modifications. And October is the earliest time in which we can start actually receiving applications. Now, why do we have to send our draft admission policy to the patron? Well, that all emanates from the Education Act, which says that we should have and shall publish. And we have to do so in a manner that is in accordance with the agreement of our patron bodies. And in relation to that, patron bodies, in fact, my information is from our clients who've been in touch with our education team, that the patron bodies actually have written to schools, and they have given directions. And in particular, I do know of some patron bodies who would have returned draft policies where issues like the characteristic spirit of the school was not inserted. So the patron body has a very significant role in all of this. So why the rush to the end of April? Well, it's very simple. The Minister for Education commenced the Act on the 1st of February of 2020, and there's a 3-month period to the end of April in which these draft admission policies must be submitted. Among the commencements are the substantive part of the Act, so the policy is the key issue here, and also the novel issue of an annual admission notice, which you will draft a parallel to the policy. And to their credit, the Department of Education and Skills have issued a circular 7/2020, and that has templates for both policy and notice. So the question the team gets from time to time, do we have to stick by the templates? Well, strictly speaking, you don't, but it wouldn't be advisable not to do so. Why reinvent the wheel, and why stray outside the guidelines that are given there? In relation to the question of oversubscription, with the best will in the world, the only people who will scrutinize your policy are parents who have had their applications refused. So it must be said at the outset that while we have templates, there are discretions there in relation to the criteria and who you can prioritize, as long as you don't discriminate. And they relate to siblings, children of former students, etc., and children of staff. Now, this brings me to the first question, which I'm going to direct to Liam. And this is the question is, we've always prioritized the enrollment of children of staff in our admission policy. It is a big issue for our staff, and let's face it, we're talking about a very small number of places here. But we're receiving conflicting signals. You seem to be saying, some people are seem to be saying that this doesn't, we cannot do this anymore. Others are saying we can. What is the correct position on this, Liam, as we have to send out the draft policy to our patron next week?
Yes, David, this is a contentious issue. We are aware that there has been mixed messages on this from the Department of Education and Skills. However, the Act itself is quite specific. Section 62(7)(e)(4), to be precise, says that in considering an application for enrolment, you cannot take into account the occupation, financial status, aptitude, academic ability, etc., of the parents of the applicant student. And by definition, if you prioritize the enrolment of children of staff, you are taking into account the occupation of the parents in allocating the place. So on the face of it, the Act is clear. You can't do this. However, this appears to be an unintended consequence in the Act, in that when it was going through the Oireachtas, the Minister, Richard Bruton, made it clear that he favoured schools retaining the right to prioritise the children of teachers, and he emphasised teachers and not staff. So he clearly was of the view that he wanted schools to retain this right. However, the Act doesn't retain that right. And I think we have to put out a health warning that if you do include such a proviso in your Act, even if it's approved by the patron, it runs the risk of being overturned on appeal under Section 29. So it comes with a health warning, David.
Thanks for that, Liam. And if I could turn to Paul just in relation to another question in relation to prioritisation. And this concerns, it goes, traditionally we have prioritised the enrolment of nieces or grandnieces or nephews of members of the congregation who are our trustees. And the query says, this is an important part of our school culture. Can we continue to do this in our new policy, Paul?
Well, David, the simple answer would appear to be yes, you can. The scheme of the Act is that it sets out a basic principle in terms of admission, and then it sets out a number of criteria that you may not take into account when considering applications for admission, including, as we've just said, the occupation of the parents. But the relationships, such as the one set out in that question, with members of religious orders, trustees of the school, etc., that's not set out in the Act as a criteria that is excluded. So it would appear that you can, but as with all of these things, and as we'll continue to repeat throughout this discussion, the new scheme and the new Act has yet to be tested in the field, and you may have a challenge from somebody who has been denied place on the basis of that criterion. But for the moment, it would seem you can proceed on that vein.
So that's good news, Paul. Thank you. We'll now move on to some other issues. And the admission policy itself, we cannot publish it earlier than the 1st of September. October is the earliest date that we can start accepting applications. Parents must be alert to the process after this date, and the whole idea and intention is that there's uniformity across the state. And there also is a very important section dealing with an admission statement, prohibiting the 9 grounds of discrimination, and that must be in your policy. Now, there are mandatory aspects of the admission policy, and amongst those are, it basically states very boldly that all applicants shall be admitted unless the school is full or the parents have failed to give a written undertaking to accept the code of behaviour. So the continual question we're getting to the education team, and we've discussed that at our education team meetings, are can we continue to use exceptional circumstances in relation to health and safety and special education needs? So I've got questions here that I'm going to direct. I'm going to put the first question to Liam, and it's as follows. In our old policy, we have a proviso that entitled us to refuse to enroll a student with exceptional SCN. Thankfully, we never had to implement that part of the policy. However, it was a comfort to us to know that in extremes, we could, if we had to refuse an applicant with such a range of special needs, that we knew we would not be able to cater for them in a mainstream setting. Can we keep that clause in the new policy? And that's notwithstanding the fact that schools are very welcoming of special education needs applicants, and over the last 20 years have been transformed. But equally, this proviso, Liam, what's your take on it?
Yes, David. You can no longer continue to have such a proviso in your policy. As you said, Section 62 of the Act says a school shall admit each student seeking admission to the school other than in the specific exceptions that you mentioned. So we used to advise schools to include such a proviso simply to cover very exceptional circumstances. Schools are very welcoming places, and we had very few cases of schools which relied on that particular policy or that particular section of the policy to refuse to enroll a child. However, it's now gone. The Act is clear that you cannot refuse to enroll a child other than in very specific circumstances. And so this could give rise to issues where an applicant to a special unit, for example, may not qualify for enrollment into the ASD unit, for example, but would be eligible to be enrolled into the mainstream school. Because I should have said earlier that the only exceptions to this rule are in the case of special schools and in special classes. So it's very foreseeable that a circumstance will arise where a student could be refused enrollment in a special class while the mainstream school would have to enroll that child. So I think that is going to be an issue going forward. We'll have to see how it works out in practice.
So Liam, any school that would continue to keep this in their new policy, we should give the health warning loud?
Absolutely. I think I don't see it standing up to appeal under Section 29.
Thanks for that. Basically, another issue is health and safety. And Paul, I have some questions for you. And the first one is, we had a clause in our previous policy which entitled us to refuse to enroll a student who we had reason to believe would pose a significant threat to the health and safety of other students and our staff. We put that in following an incident where a pregnant teacher was injured by a student with behavioural issues who transferred into our school. We were determined that something like this would never happen again. We want to keep this in our new policy. And a desperate query, can we continue to do so? Paul?
Well, David, as Liam says, and as you pointed out, the statement in the Act is quite bold and clear, and not open to equivocation. You can only refuse admission if the school is full or if the parents fail to give written undertaking. So in this type of circumstance, similarly, I don't think a clause that excludes admission or prevents admission on the basis of that type of situation is going to stand up. As the query says, it's more likely to occur in a primary school setting where there's a transfer from another school. So that raises 2 points that also come up under the new legislation. Firstly, that while the primary focus of the legislation is on initial intake groups, which in primary schools, junior infant classes, admissions other than in the primary intake group, the initial intake group, are also subject to the provisions of the Act. So any admissions by way of a transfer later also have to be conducted in line with the Act in terms of the non-discriminatory clauses of it. The other issue is, how would you know about these potential health and safety considerations? In the past, it would be typical to ask for copies of recent reports. The Act now says you're not allowed to take into account academic performance, which typically would have been the basis for asking for those reports, and you would get lots of other information too. So it would appear that avenue has been closed off as well, because by asking for the reports, you're implying that you're considering or taking into account academic performance in considering your admission. So there are lots of things that come out of that, but the short answer to that is no. If an application comes in and it's otherwise good and valid, then you will have to admit that student unless there's some other reason not to.
So there's a double whammy there, Paul, just in relation to getting the reports along with that. And as a rider to that, there's another question which in some ways may have anticipated your opinion on this. It says, if we kind of keep this option in our policy, where does that leave us as employers, i.e. the board, in terms of our duty of care to staff and students? How do you reconcile that, Paul, with
the duty of care continues and remains there. I think the difference is that you're not taking a preemptive step in line with that duty of care by refusing an admission, but you will be required, a board will be required, a principal will be required in practical day-to-day management basis to be diligent in looking at that situation, taking action where required, making sure that staff are properly trained in relation to dealing with situations like that, and maintaining records of that training. So there are all sorts of implications coming out of that in terms of duty of care, where a high level of diligence and attention to the various aspects of, for example, safety statements, and making sure those are up to date and renewed, will come out of those types of situations. So boards are going to have to be on top of that under the new system.
Thank you for that, Paul. And we'll head on to our next slide. And this is the annual admission notice. And that's going to be very much nuts and bolts. How many places you have in your intake group? If you have a special class, how many places are available there? And how you can, as a parent, access admission and enrollment forms. Our next piece will look at timeframes, and this is, we must afford our parents a 3-week minimum opportunity to apply for a place in a school. Some schools extend it out for much longer, but there's a 3-week minimum. And then there's a 3-week maximum in which the applications must be processed and notified. And obviously, there is a period that would be required for an applicant to confirm acceptance of the offer of admission. Now, just looking at, again, queries that are coming into our education team over the last few weeks and that, in a case where offers of admission have been accepted prior to the 1st of February, the school should set out the numbers of such offers and acceptances in the annual admission notice. And we have questions here in relation to this. So the first one is in relation to the the Act seems to require us to keep a waiting list for the entirety of the school year. I can see this causing problems for us from an education perspective, particularly if a vacancy becomes available in junior infants, for example, late in the school year. So if here we are on the 21st of April, a vacancy occurs in junior infants, and are we required to offer this place to a child, even though the year is almost gone?
David, the answer there is you are. Schools have to maintain waiting lists, and if a vacancy arises, albeit coming towards the end of the school year, that vacancy has to be offered to the next person entitled on the waiting list. However, in reality, it remains to be seen how that's going to work out. It's quite likely that somebody who wanted to go to your school, who's enrolled elsewhere, may be happily embedded in that other school and may not wish to take up the offer. So yes, you do have to make the offer if a vacancy arises, but the human reality will dictate what the response to that offer is. So let's wait and see how it works out.
Okay, Liam, and just a follow-up question for you also. We were always oversubscribed, and we've traditionally maintained a waiting list from which we allocate places in successive school years. We've written to parents informing them that their children's names are on this list for allocating places into the future. Some parents have formally accepted places, most haven't. Can we only allocate places to students whose parents have formally accepted the offers?
The short answer to that is no. The key thing here is that if you are a school that has maintained a list from which you allocated places in subsequent school years, as long as that list was prepared before the 1st of February 2020, when the Act came into effect, you can rely on it. And the key thing here is that if the school, in response to expressions of interest or applications from parents, wrote to those parents informing them that their children's names would be kept on the list and that places would be allocated from that list, the Act doesn't say that the parents have to have formally accepted those offers for that list to be valid. So in other words, the key thing is that the school made the offer in writing to the parents rather than the parents having confirmed in writing. So it doesn't really matter whether the parents confirmed in writing or not, the list is still valid. There's a time limit on it of 5 years. So this option will ultimately go, but it's valid for the next few years anyway.
That's great, Liam. It certainly bring great clarity to that question there. We're now going to move on, and we're going to look at prohibitions in the policy. And apart from the timing of receiving applications before 1st of October, we know that attendance at preschool now is not allowed, much to the disappointment, I think, of a lot of schools, with the exception of JESH schools where you have early start or intervention classes. Now, there's another requirement there, prohibition on the requirement of parents to attend for interview. And I must say, when I read that, I felt disappointed, because I think it's a key part of the enrollment process. So can we invite people for interview even though we cannot compel them? So Paul, what's your take on that?
I think you can still invite parents, prospective parents, to attend for interview or for an open day or an open evening. I've seen that in some draft policies, but the quite clear position is that you can't compel them to attend. And the follow-on from that is that you have to be very careful then when implementing the selection process, and which will be the responsibility of the principal. I think it's important to note that as well, that it's the principal who is responsible for implementing the policy set down by the Board of Management. So it'd be the principal doing this on the ground. You have to be very careful that there's no mention or no reference to the fact of whether or not parents attended for an open day or an open evening or a meeting, on the basis that if there's any suggestion of that, it may leave the process open to challenge if one of those parents or sets of parents is then their child is unsuccessful in gaining a place. So you can still have them, you can't make them compulsory, and you need to be careful how you treat the fact of attendance or non-attendance afterwards.
Thanks for that, Paul. And just in relation to the cap of 25% on children and grandchildren of past pupils, that provision emanates from a successful case that Mason Hayes and Curran took in relation to the Stokes case in Clonmel in Tipperary, and it was successful. However, we don't have time to go into the details of it, and other cases like Scullmaloga too, which Mason Hayes Curran undertook, have led to some changes in the legislation. We're going to move on as to what schools must include, and they must provide a waiting list, and they must set out procedures if 2 or more pupils are tied for a place. And we had a situation on occasion where twins were tied for a place and firstborn got priority. Not very satisfactory for the parents, but so be it. We must give reasons for the refusal and the number on the list, and inform unsuccessful applicants that they may appeal in the first instance to the board and afterwards to the department in a Section 29 appeal. So there are 2 pieces there. I'm going to ask Liam just about time limits. Would it be wise for a board to insert time limits in which a parent can make an appeal to the board, appealing a principal's decision, which was alluded to by Paul, and then a time limit for the board to turn around that decision? So time limits, Liam, what do you think? Liam, you'll have to unmute Liam there. We can't.
Yeah.
Sorry, Liam.
Sorry, David, apologies for that. There's nothing in the Act about time limits for appeals to boards of management. However, we think it's a good idea for schools to include such a time limit in the admissions policy. Something of the order of 3 weeks from date of receipt of the refusal within which to make an appeal. There are a lot of practical reasons why you should do that, not least facilitating your board in dealing with possibly multiple appeals from refusals. The way the Act is structured, a refusal to enroll is a decision of the principal in the first instance, and it's appealable to the Board of Management. And that is now a statutory right. So schools will have to be very careful as to how they conduct the appeal process at board level. We think there's going to be a greater focus on school governance in relation to the conduct of appeals, as a parent who's unsuccessful at the appeal stage could very well judicially review the school in relation to its conduct of the appeal, even before the matter went on to a Section 29 hearing.
Thank you, Liam. And Paul, have you anything to add in relation to the way that the board will conduct these appeals?
Just very briefly, I would say that as Liam says, maybe will be subject to more scrutiny, may be subject to judicial review. I think it would be important, therefore, that boards would have an agreed procedure, whether that's agreed by themselves or agreed in conjunction with their patron, so that it's consistent across all schools under that particular patron, for conducting those appeals, so that when they are queried on that, they can say, well, look, there's the procedure we had in place beforehand. and that's the procedure we followed, and that's what we'll be judged on. Whether that's set out in the policy or not is an open question, but there's no reason why it couldn't, but it might be set out in a separate document. But I think it should be agreed in advance of getting any of these appeals in, so sometime before October.
Thanks for that, Paul. We'll now move on to the parents have obligations. I won't go through that in much detail, but they must indicate if they've accepted an offer in another school or if they've applied and are awaiting confirmation. I think the next piece is in relation to data protection. I'm going to ask Paul to come in on this piece there, sharing of information by one school with other schools and the patron. What's your take on that, Paul?
Look, data protection is a delicate issue at all times, and particularly where children are involved. There is an obligation on parents to notify schools and boards of other applications they may have made or other places they may have accepted, but the Act also allows schools to share that information amongst themselves, which might take place in a particular geographical area or under a particular patron. All the schools under a particular patron may agree to share that information. But I think, again, similar to the procedures for the appeal to the board, I think it would be important that boards would give some consideration to the protocols around handling and exchanging this data. And they may want to do that in consultation with either other schools in their area, or probably they would be well advised to liaise with their patron body or bodies in relation to that as well, to make sure that that's agreed and set down before this data starts to be shared amongst schools. So again, it's just protecting the schools and the boards before they actually take the steps to implement these provisions of the Act, that they have an agreed protocol or procedure that will keep them on the straight and narrow, so to speak.
Thanks for that, Paul. We'll move on now. Just in relation to the question of withdrawn an offer, Paul, if I could ask you there in relation to, it's fairly straightforward in relation to the code of behaviour and not confirming an acceptance, but in relation to the other two headings, again, how do you feel about that?
Yeah, I think the first and the fourth point on that particular slide, look, if you find out about that before you have finalised admission to the school, that's fine. You might be able to withdraw the offer. Or if you find out before you've made the offer, you might refuse an offer of a place or not offer a place on the basis that incorrect or false information has been provided. I think if you find out about those things after you have admitted the child to the school, then I think the application of this Act has ceased to be, in that the process has finished. The child is admitted. They're now in the school, and I think it would be very difficult to try and apply the provisions of this Act at that point in time. You may have other recourse if you wish to follow it. But I think, because people have asked about people giving false addresses, etc., to come within catchment areas. I think, look, it's a very difficult situation, but I think if you find out about it before, you have room to maneuver under this Act. If you find out about it afterwards, it's a more difficult situation, and I think further advice would be required.
Thanks for that clarification, Paul. Just we're coming to the end, just want to highlight provisions in relation to Gael Scoilina, given priority to Irish-speaking children, and the likely regression of a child if they're not admitted. There are stipulations there. However, the level of fluency cannot dictate rankings. And also, I know we're going through these slides very quickly, but just to highlight them, Liam has already dealt with the special class provisions. We'd ask you to be mindful of that. And we also have a little slide here dealing with the minority religions and the provisions for children applying to these schools, and how special classes are not subject to those exemptions, just to be aware of that. Just in conclusion, this Act hasn't been road tested. So I know that Liam and Paul and Hurley and all the rest of the team have been involved in many judicial reviews, and not to mention Section 29 appeals. Will clarity come out of the dreaded Section 29 appeals and judicial reviews? Would that be your view?
David, I think it's foreseeable. It's almost certain that that issues will arise into the future. We've been involved in all of the major High Court challenges in relation to admission and exclusions in schools. And the one thing I'm very confident of is that where issues do arise in the future, where there is a challenge or where there is a need to challenge a decision of a Section 29 committee on the part of a Board of Management, we will be more than able to meet that challenge and to rise to the occasion. Issues will arise in relation to the implementation of this Act. That's a certainty.
Thank you, Liam. Okay, just as we move on, we produce regular easings, and we're giving you just the contact details there, particularly in relation to the admission policy. Working remotely from home is another big issue. We're all doing that, as you can see, and well done to schools on the huge support that they're giving to children in relation to their teaching and learning. We also have an easing that you might be interested in relation to diverting surplus teachers and SNAs to deliver essential public services. You'll find all of that on our website. And just finally, in conclusion, just to say that our head of education, Hurley, will be writing, he'll be sending an email out to each and every registered person. And in that, we'll be having the webinar if you'd like to view it again. And also, we'll be given details of a package of support that we can give to boards if you feel you need such support. And in conclusion, we'd like to thank you for your questions. We apologize, we just couldn't get, we were overwhelmed by the amount and gratified by the amount of people who have logged in. So just to say thank you very much, and we wish you all the very best. I'd like to thank Liam and Paul again for their help and all the team. So we want to wish you the very best of luck and in getting your draft admission policy over the line by the 30th of April. Thank you.
Thank you.
Thank you.